Right, may I welcome you all on behalf of Classics for All to this event. You will hear more about Classics for All later this evening. But first, the legal business. The Supreme Court has hosted some important events in recent weeks, but none so momentous as the trial which you will witness this evening. We have sitting over there Lysistrata, and we have here her husband. The husband is petitioning for divorce, and Lysistrata is defending that claim. I ask you all to step back in time 2,500 years. It is 411 BC, the year when Aristophanes first put on his well-known play Lysistrata. The year 411 was early in the final phase of the Peloponnesian War. Things were going badly for Athens and well for Sparta. Aristophanes' play Lysistrata is built around two themes: the absurdity of the Peloponnesian War and the absurdity of excluding women from any role in politics or national affairs. So in the play, the fictitious character Lysistrata takes matters into her own hands. She gets in league with all the Athenian wives and all the Spartan wives, and she persuades them all to go on strike until their husbands stop the war. She also, together with the Athenian women, particularly the older Athenian women, occupies the Acropolis, where the Athenian treasury was kept, thus making it impossible to fund the war effort. So that is the essence of Aristophanes' plot. Aristophanes doesn't tell us anything about Lysistrata's husband, but she must have had a husband, and he, like all the other husbands in the play, must have been furious about his wife's conduct. Hence the divorce proceedings which you are now going to witness. The judge will come in, provided she's heard her cue. Mary?
All rise.
Good evening, everybody. We'll treat this case as called on, and the name given for the purpose of the record, and I'll call upon the appellant to begin the appellant's argument.
My lady. This is a petition for divorce based on Section 1(2)b of the Matrimonial Causes Act 1973. That ordinarily extends to England and Wales. However, the purpose of this hearing, it also extends to Athens and the conduct of the respondent of a citizen in the town. The petitioner alleges that his marriage to Lysistrata has broken down irretrievably and that she has behaved in a way that he cannot reasonably be expected to live with her. That is the legal test. So in considering the evidence and the facts of this case, the focus is accordingly: was Lysistrata's behaviour such that the petitioner could no longer reasonably be expected to live with her? It's our submission that the facts show that clearly he could not. Now, whilst the facts of this case arise within the historical context of the wars placing pressure on Athens in 413, the law which governs your approach to the facts is the law which exists today in this green and pleasant land. We will ask you to consider the conduct based in a historical context, but with today's legal approach. Now, I warn you, the facts may make you blush. The detail of the conduct of the respondent and those other women she ravelled up into her desperate actions may make you feel frustrated, as frustrated and confused as their poor beleaguered husbands. But the facts are the matters which we must face square on and consider with reference to the Matrimonial Causes Act and to the assessment of Lysistrata's unreasonable behaviour. Before turning to the facts, let us first consider the most recent case in which the question of unreasonable behaviour has been considered, that of a decision here in the Supreme Court, case of Owens and Owens in 2018. In summary, that case held that when applying section 1.2b, the correct inquiry is, firstly, by reference to the allegations of the behaviour in the petition, to determine what the respondent did or did not do. Secondly, to assess the effect which the behaviour had upon this particular petitioner, in light of all of the circumstances in which it occurred. And then thirdly, to make an evaluation as to whether or not the respondent's behaviour and the light of effect on the petitioner, you have an expectation whether the petitioner should continue to live with the respondent, and would that be unreasonable? This test has been applied for many years, but the application of the test to the facts of an individual case has changed and is likely to change over time, in line with changes of the wider social and moral issues. The most relevant change over the past 40 years, of course, is the recognition of the equality of sexes and the marriage of the partnership of equals. I want you to hold that in your mind, please. I'm just going to take you through some of the cases that came before Owens so you can understand the application of facts to this concept of unreasonable behaviour. The first is way back in 1972. Well, not quite as way back as where Lysistrata sits. And that's in the case of Pheasant and Pheasant, when a husband petitioned divorce, not then within the 1973 Act, but within a similar act, the Divorce Reform Act in 1969. And the husband's case was that the wife had been unable to give him demonstrative affection, which he needed. In that case, the petition was dismissed, and the judge hearing that case construed section 2.1 of that act as placing primary emphasis on the respondent's behaviour, rather than the petitioner's personal idiosyncrasies. That judge asked himself whether it was reasonable to expect this petitioner to put up with the behaviours of this respondent, bearing in mind the characters and difficulties of each of them, and trying to be fair to both of them and expecting of them neither heroic virtue nor selfless abnegation. We move on then a couple of years to the case of Livingston-Stallard and Livingston-Stallard. There's a theme of, obviously. And they upheld the wife's petition based on the same subsection. And in that case, the learned judge suggested it was unhelpful to analyse conduct required by the subsection in terms of its gravity. And whilst he purported to distance himself from the decision in Pheasant, the question he asked himself seems similar. Would any right-thinking person come to the conclusion that this husband behaved in such a way that the wife cannot reasonably be expected to live with him, taking into account the whole of the circumstances, characters and personalities of the parties? You see, there's a theme evolving. The third case to consider was this issue was Thurlow and Thirlwell, still in the 1970s, and in this case, the husband's petition under that subsection was based on the wife's failure to contribute to the running of the home and to her increasingly erratic behaviour, both of which, unfortunately, were because she had a neurological condition. In that case, the court held that the behaviour could arise as a result of a respondent being unwell, and it could arise where no blame could be apportioned to the wife, something we may turn to later. In 1981, in the case of Barrage and Barrage, giving the leading judgment, Lord Justice Cumming Bruce offered this analogy. In behaviour cases, the court has to decide the single question whether the husband, for example, could be a wife, has so behaved that it is unreasonable to expect the wife to live with him. In order to decide that, it is necessary to make findings of fact of what the husband actually did and then, taking those findings of fact, consider that the impact of that on the lady. As has been said again and again, it's the actions between a particular husband and a particular wife, whose conduct and suffering are under scrutiny. So when you're considering the facts of this case, I ask you to hold that in mind. There is, of course, always a subjective element of the totality of the facts, and as they're relevant to the solution. But when that subjective element has been evaluated, at the end of the day, the question that falls to be determined, and will be determined by you this evening, is an objective test. My final case for you to consider is Buffery and Buffery, and we're in 1988 now, and in that case, a recorder had dismissed a wife's petition under the subsection on the basis that the petition had failed to establish that either the husband's behaviour had been grave and weighty, or that it had even caused the breakdown of the marriage. And the Court of Appeal held that behaviour under the subsection didn't have to be grave or weighty. And in order to understand the context, therefore, of this petition, and to assist you, the court, fellow citizens, to assess the effect of the behaviour of Lysistrata on her husband, it's necessary to place the marriage and behaviour in a context. And the context you're considering, therefore, balancing then and now, is that, as we've already heard, war had been waging in Athens between the Spartans for many years. In late 413, news reached Athens of the total destruction of their expeditionary forces in Sicily. At one blow, the Athenians found themselves with virtually no navy, and it seemed without any hope. Spartan land force had already occupied the strong point of Decelea in Attica, and it seemed that the Spartan forces might at any moment choose to attack Pyrrhus. It looked as though many of Athens' allies were trying to seize the time to change allegiances, and Persian provincial governors competed with each other for the honour of bringing back under the great king's rule the Greeks of Asia Minor, who'd been revolted many years before. And now it appeared to be that the power of Athens was crumbling. However, no final blow came. No final attack hit Athens, and the Athenians were able to rebuild their navy using a special reserve held in the Acropolis. It was set aside some 20 years before, and that money was safe now in a temple inside the Acropolis. It was ready for the fighting fund. Then came the Respondent and her band of merry women, a mixture of some nubile, some married, some older, and they came together to seize, under Lysistrata's plan, the Acropolis. And worse than that, their plan was to withhold sexual favours and intercourse from their husbands, until the men caved under the physiological strain of never-ending erections. And together, Spartan, Athenians, Persians would then, said Lysistrata, sign a peace treaty. So let's then consider the facts of this case. It is for this court to assess the impact of the behaviour of the respondent on the petitioner, not of the peace negotiations, nor indeed on the lives of the merry other women that came to be affected, or of the men that were affected, nor should you assess the threats that she brought to bear on her friends, Kalonike, Marine, and even her old friend Lampito, the wife of a Spartan fighter. But you must assess it on her husband, the petitioner, for it is his response, his feeling to the behaviour of Lysistrata and the interplay between them that you, the court, must consider when applying the test in the act. One may consider that the entire aim of Lysistrata's decision to deprive her husband of sexual intercourse was to drive him insane, to make him feel ill and at odds with himself. She wanted him to feel desperate, to feel so ill with the need to relieve himself, so ill that he and all the other men and esteemed leaders would fall to their knees and do what the women wanted. She acted in a way which she knew would cause him distress, and such distress that he would be forced to act contrary to his commission, contrary to his oaths of allegiance to protect Athens. The evidence shows that she drew oaths from those she pulled into her plot, and those included declarations such as, "I will not allow either lover or husband to reproach me in a state of erection, and I will live at home in unsullied chastity. I will wear my saffron gown and my sexiest makeup to inflame my husband's ardour." The respondent recognised the conduct may drive her husband, the petitioner, to acts of rash behaviour, but described in detail how to taunt the men, amongst them the petitioner, her own husband. Just imagine, she says in the evidence, we're at home, beautifully made up. We walk around the house wearing sheer lawn shifts and nothing else. The men are all horny and can't wait to leap upon us, but we will keep our distance and refuse to let them. The impact of the withdrawal of sexual acts was not only willful, but designed to do harm. It is the epitome of unreasonable behaviour. It made the men unwell. Evidence is they were suffering cramp attacks into the small hours. It did indeed bring them to their knees. Lysistrata knew this, because as the evidence shows us, when asked by her friend Marine, and if they beat us, the respondent answered, just make yourself frigid. There's no pleasure in it if they have to use force. Make life a misery for them, and they'll give up trying soon enough. No man is ever going to get satisfaction if a woman doesn't choose that he should. In her defence, you may hear Lysistrata arguing that she was trying to bring about peace, and that peace is the most noble of objectives. Further, that of course she was trying to help the nation. Those representing her may seek to persuade you that her actions were far from unreasonable. They were noble and considered, they may argue. Without her, those representing her may claim, the war may have continued for years and years and years with the loss of loves and lives. However, a careful consideration of the evidence appears to demonstrate that instead she was focusing on her own selfish view of the war. Her concern appeared to be more that she had to live a chaste life without the presence of her husband to meet her sexual urges, that the children were without fathers, and men were gone for months and months at a time. It appeared to be the aim of the women was merely to bring their menfolk home. See the statements, please, of Kalanake and Mirin, who attest to being asked whether they missed their menfolk when they were away at war, and how Lysistrata enveloped firstly women whose husbands were away, or those who had lost men in the wars, into her plot. Note, too, the evidence from a learned magistrate, that Lysistrata and others complained to him how unfair life is, that a man may come home after years at war, old and grey, and can take a younger wife, whereas women who have lost their bloom are stuck, often alone and unable to remarry. Her focus was on how best to further womankind and their restrictive lifestyle, rather than any real focus on the war, what it means to the men who fight in it and the rewards it can bring. By starting this plot, by leading the attack on the Acropolis so that no man could enter, the respondent did indeed bring Athens to its knees. She did so with rash abandon, with no thought for the impact of her actions, no thought of the impact of her actions on the petitioner, his role in the army, his ability to further his career, avenues for future career progression, financial gain and long-term security. She didn't think of the impact of her choices and on her behaviour on her own husband. Further to that, she failed to consider too the gamble she was taking in barring all men from entering the Acropolis, thus preventing the national army from financial resources it needed to support the navy and other forces. For there and only there was the treasure and the finances needed to refuel the navy, to maintain the war. Her actions closed the doors to all who required access to those national funds. Whilst her aspiration was to bring about peace, she could not know that her plan would work. She risked the safety of her nation. She risked the safety of the petitioner, her husband. She and the women created a band of men incapable of fighting, overcome as they were in physical pain and tumors they could not control. Many were hidden beneath cloaks, almost dying of erectile hyperfunction. Further, her actions deprived the citizens of Athens from retrieving the heroic victory open to them. They had taken time to build a new navy after the previous total destruction of their forces, and were now again ready to stand up and protect the honour and safety of their community. But the respondent prevented them from achieving that honour. Rather, she humiliated them, bringing them to the knees, crushing their dignity and wreaking havoc with their manhood. That conduct must be considered not on the national security, but on the petitioner and their marriage. Ask yourselves, please, what effect did the respondent's conduct and behaviour have on her husband, the petitioner? Her behaviour was clearly unreasonable, but it is acknowledged that the subsection requires not that the behaviour should have been unreasonable, but also that the expectation of continued life together should be unreasonable. The respondent rendered her husband a laughingstock. His colleagues and leaders across the nation know now that his wife has the power. She can command him, just as she did others, to bend to her will simply by the removal of sex. He lost his respect and positioning in society. Recall, please, the earlier cases when we talked about the equality of marriage, the sanctity of marriage. She removed that equality. Even if she's now seen openly as a hero, his friends and colleagues know how she controls him. They know where the balance of power in their marriage lies. He knows how she was used as a pawn in their plots. The respondent's behaviour destroyed his faith in their marriage. She didn't share her plans with him. She didn't seek support from him in her plans. She demonstrated a monstrous lack of trust in him. This man, her partner, her husband, her confidant. She betrayed his trust in her in the most awful and devious of ways. She used sex as a weapon and undermined the sanctity of their union and the trust upon which it was founded. Her actions destroyed their marriage. Returning to the case of Hales, and I want to end with something that our president of the Supreme Court, Baroness Hale, drew out. If you want to read it, it's at paragraph 50 of the case of Owens. She argued that the law in the Matrimonial Causes Act could be seen with analogy with constructive dismissal cases, just as it was argued in a case in the Employment Tribunal. In that case, it was held that the meaning that correspondence or observations have when they're directed by one person to another often depend very much on the context of the relationship between the two. Looking at incidents in isolation is perhaps to fail to see the eloquence of the story painted by the whole of the series of events, and to focus instead upon events taken individually, as though they were in silos. In a constructive dismissal case, that arises out of a poisoned relationship between parties. And what matters is the totality of the picture, rather than any individual point along the way. And I want you to hold that, please, when you consider the totality of the picture of the respondent's behaviour and the impact upon the petitioner. And as Baroness Hale held in Owens, those who have never experienced such humiliation may find it difficult to understand how destructive such conduct can be of the trust and confidence which should exist in any marriage. In this case, the totality of the story is the breakdown of the marriage, the breakdown and loss of trust between the petitioner and the respondent, the breach of trust by the respondent and her conduct towards the husband. It's not about Athens, it's not about the Acropolis, it's not about peace or the end of the war, but it's about her actions as a wife against her husband, those actions that harmed her husband and destroyed their marriage.
Thank you very much. Ms. Hannah, do you follow?
My lady, members of the jury, fellow citizens of Athens. So, how to distill the facts of this case? I am going to remind you all, as set out by my learned leader at the start of her submissions, of the 3 questions you must all ask yourselves when considering whether or not to grant this petitioner his divorce. And those 3 questions are in line with the authoritative inquiry as set out in Owens. So first, with reference to the allegations of the behaviour, determine what the respondent did or did not do. In this case, this inquiry is easy enough. There is no dispute about what Lysistrata did or did not do, or any dispute about her conduct. She does not deny her actions, and indeed she cannot, for it is a matter of public knowledge. So what did she do then? We know that she organised and orchestrated the occupation of the Acropolis, with the express purpose of restricting the people and city of Athens from accessing vital funds in order to undermine the war effort. What else did she do? Well, she rallied and encouraged not just the women of Athens, but those of Sparta and Thebes to withhold all affection, romantic intimacy, and sexual activity from their husbands, but with the express purpose of manipulating them into such a state of despair and pain that they would bend their will and agree peace. She also barred these women from returning home, attending to their children, carrying out their household and other domestic tasks. Such tasks would have been the essence of Lysistrata's contribution to her marriage and fulfillment of her role in her partnership with her husband, as husband and wife. So in terms of the behavioural allegations and in terms of question number 1, what did the respondent do? It's not in dispute. It's not an issue. It is a certainty. So moving on, having established what it is that Lysistrata did, it is for you to assess the effect that her behaviour had upon her husband in light of all of the circumstances in which it occurred. The effect on her husband was devastating. Her actions in occupying the Acropolis and leading a coup over the menfolk of Athens left society in no doubt as to this man's lesser importance in his marriage to his wife. It would have been a public humiliation for him on a large scale involving huge amounts of embarrassment. Her actions in relation to the war effort would have undermined there being any scope for her husband to advance his career prospects and deprive him of any glory that we know can come with the victory of war. She selfishly snatched that opportunity away from him, but with no thought to the demoralizing effect it would have on him. In withholding affection and love and physical intimacy, Lysistrata withdrew from her marriage, with the effect that these parties ceased to exist as man and wife in the most essential way. The impact that this had on her husband was to leave him feeling unloved, unwanted, unimportant, merely a thing to be trifled with to further her own ends. But the impact of her conduct went beyond emotional scars, because her behaviour left him in physical pain and impacted his medical health. Man is not supposed to function in, as my learned leader so aptly put it, a constant state of erectile hyperfunction. That is not how man was designed to exist. But Lysistrata gave no thought to the fact that her conduct had a very real and quite dangerous impact on his health. There were examples of it being potentially life-threatening in the other menfolk, had their course of action continued for much longer. It is arguable, therefore, that in withholding sexual intercourse from her husband, her actions went so far as to potentially endanger his life. And by not fulfilling her share of household tasks and duties, she demonstrated a disregard for her marriage as a partnership, and a partnership of equals. This had the impact on Lysistrata's husband of leaving him feeling as if she were no longer invested in their relationship. She had, to all intents and purposes, disengaged, with no care for the state of their marital bliss. So, ask yourself the effect which her behaviour had on this husband. In all the circumstances, it can be described as nothing less than ruinous. to our third and final inquiry, to make an evaluation as to whether or not, as a result of her behaviour, and in the light of its effect on her husband, whether or not it would be reasonable to expect that this man should continue to live with this woman as his wife. And at this stage of the inquiry, what you must remember is this, and that is what is not relevant to your consideration in reaching your decision. What is not relevant is whether her behaviour was reasonable. What is not relevant is whether or not her course of action was justified or proportionate to the end goal, nor whether her actions were ultimately successful. None of those questions are relevant because it is not the inherent reasonableness of the behaviour that is to be considered in the test. It matters not, in applying the law, whether you are of the view that she acted in the right. What is relevant is whether or not her behaviour was such that any right-thinking person, would they come to the conclusion that it's reasonable to expect this man to continue to live with this woman? I pause here to return to something Colonike asks Lysistrata when she's considering whether or not to join the cause. She asks, "But if, which the gods forbid, we do refrain altogether from what you say, should we get peace quicker?" Which the gods forbid. How can it be reasonable to expect this man to continue to live with the respondent when she has openly and flagrantly defied the will of the gods, the ultimate source of power and wisdom in society? The gods are not particularly known for their mercy and understanding. He cannot be reasonably be expected to share his home and his life any more with such a woman and risk the wrath of the gods on his household as a result of her behaviour. The cumulative effect of her actions and the impact on her husband have broken, and broken permanently, the foundations of trust and mutual respect that had previously underpinned their marriage. There is no scope for reconciliation. The impact on him has been too severe. No right-thinking person could possibly come to the conclusion that it's reasonable for him to continue to live with Lysistrata. As such, on behalf of the petitioner, we ask you, wise members of the jury and fellow citizens of Athens, to find that this marriage has broken down irretrievably and that Lysistrata has behaved in such a way that he cannot reasonably be expected to live with her and to grant him the divorce he so desperately seeks.
Thank you very much, counsel. Thank you. Then we're better move to the respondent's case. Mr. Garida.
Yes, my pleasure, Ladyship. At the outset, may we thank your Ladyship for agreeing to try this unmeritorious divorce petition with a jury. 161 years ago, the Matrimonial Causes Act of the time transferred jurisdiction from the ecclesiastical courts to the civil courts. And with this development came the introduction of the right to elect trial by jury. The use of such juries in these cases became widespread, not least because husbands considered they could rely on a male judge and an all-male jury to return a verdict that would favour him. Now take, for example, my lady, the case of Mr. and Mrs. Synge. This was tried in our courts 118 years ago, and the then president and a jury considered the following facts. Mr. and Mrs. Synge returned from India, where Mr. Synge had completed a tour of duty in the British Army. But when they came back to England, he left his wife and took lodgings on the Kent coast, somewhere near Folkestone. When he was there, the jury of the time found that he had committed adultery with a surprisingly aptly named woman, one Miss Hooker. However, his wife was denied a divorce on the grounds of adultery. Instead, the court preferred to allow the husband's petition on the grounds of constructive desertion by the wife, citing her refusal of sexual intercourse as the reason why he was driven into the arms of his mistress. Well, my lady, that was then. But today, we are pleased that our trial is presided over by a woman, with a jury comprised of both sexes. Not, I add, because we expect in return the favourable, some may say perverse outcome enjoyed by Mr. Sinch, but because we are confident that a careful examination of the basis of this petition will result in all right-thinking citizens of both sexes concluding that it must be dismissed. So, my lady, the respondent opposes the petition on two bases. Firstly, this petition is an abuse of process. It is being brought in a jurisdiction with which the petitioner and the respondent have absolutely no connection. A clearer example of forum shopping our courts have yet to see. But secondly, we oppose it on the merits. No right-thinking person would come to the conclusion that the respondent has behaved in such a way that the petitioner cannot reasonably be expected to live with her in the future. So, forum shopping, my lady, we submit that issuing these proceedings in England represents nothing more than a cynical, nakedly tactical and frankly distasteful attempt on the part of the petitioner. Firstly, he clearly wishes to avoid his financial obligations towards the respondent at classical Athenian law. Secondly, he wishes to profit from the generous English regime on the separation of marital assets. And thirdly, he wishes to have the opportunity to prevent the respondent from commencing divorce proceedings before the classical Athenian courts, preventing her thereby from, firstly, utilising a legal procedure to protect her reputation, and secondly, from appearing before a tribunal that has more closely benefited from her actions in securing peace between Athens and Sparta. Now, the petitioner looks innocent, but he well knows that he does not require recourse to any court, least of all this court, if he's to successfully divorce the respondent in Athens. All he need do is return the respondent to her father's house. My lady, the jury will be well aware that this was the process adopted, for example, by both Pericles and Menecles, as widely reported by Plutarch. If this is so, my lady, why, I hear the jury ask, has the petitioner gone to the trouble to travel some 1,500 miles or so, making the tortuous and dangerous journey over 40 days to bring his petition before this court? Well, the answer we submit is twofold: greed and vindictiveness. Firstly, greed. If the petitioner divorces our client in Athens, he must return in full the substantial dowry that he received on the parties' marriage. We're instructed that the dowry was much as 1,000 silver talents, the equivalent, of course, of £11,500,000 sterling. Well, no wonder, my lady, the petitioner, who has become accustomed to the finer things in life, is loath to return such riches. Failure on his part to do so also incurs a punitive interest rate of 18%. Perhaps, my lady, the members of the jury are now coming to appreciate something of the nature of this man who brings the petition. Secondly, vindictiveness. In classical Athens, our client would have had the right, albeit through a male relative acting as her kyrios or litigation friend, to issue the divorce proceedings before an archon. Part of the purpose of such an action, which, unlike a husband divorcing a wife, is a matter of impartial public record, much of the purpose is to protect her against any stigma that she might face as a single, unmarried divorcee. In this way, my lady, it will now be obvious to the jury that the petitioner wishes to inflict maximum reputational damage on the respondent by seeking to deny her the remedy which she is entitled at classical Athenian law. In these circumstances, we submit, the court should be slow to allow its process to be abused in this way, and for this reason alone, the petition should surely be dismissed. Nevertheless, we turn to the merits of the petition, or rather, should we say, the conspicuous lack of merit in the petition. As my learned friend has said, the petition is brought in reliance on section 1.2b of our Matrimonial Causes Act, the roots of which find themselves in legislation now some 50 years or so old. The subsection states that the court hearing a petition for divorce shall not hold the marriage to have broken down irretrievably, unless the petitioner satisfies the court of any one of the or more of the following facts, that is to say, B, that the respondent has behaved in such a way that the petitioner cannot reasonably be expected to live with the respondent. My lady, what does this mean? Well, as my learned friend has outlined, the jury will no doubt be grateful that this question was considered and conclusively answered when only 15 months ago this very court upheld, however reluctantly, Mr. Owen's defence of the petition brought by his wife. Although it had widely been anticipated that by now new legislation would have been passed to remedy the defects in our law, members of the jury cannot have failed to notice that our Parliament, not 100 yards from this building, has been somewhat distracted by the United Kingdom's own divorce from its 27 closest neighbours, after what may be described as a long and fruitful, but at times tumultuous, 45-year political marriage. Well, addressing the meaning of section 1.2b in the Owens case, Lord Wilson said, the term unreasonable behaviour has always been the family lawyer's shorthand description for the content of the subsection. But it is wrong. The subsection requires not that the behaviour should have been unreasonable, but that the expectation of continued life together should be unreasonable. The President of the court, Lady Hale, broached the same issue in this way. Unreasonable behaviour is a convenient but deeply misleading shorthand for a very different concept, and it can so easily lead into error, particularly it can lead to a search for blame. That is not required. Indeed, those of us who have made or supported proposals for reform of the law over the years may not have helped by referring to no-fault divorce when the current law does not require fault. Worse still, referring to unreasonable behaviour, said her ladyship, can also lead to a search for who is more to blame, which is also irrelevant. 50 years ago, the Divorce Reform Act swept away the concepts in the old law relating to matrimonial offences, which made an attempt, however crude, to work out who was more to blame. Lady Hale concluded the current law simply does not do this. Well, earlier in the judgment, Lord Wilson reviewed the old authorities that had previously considered what was then new law. My learned friend has already referred to the first reported case on the issue concerning the marriage of Mr. and Mrs. Pheasant, and one might observe that the husband's petition was well and truly plucked, stuffed and roasted by Mr. Justice Ormerod, who dismissed the claim that Mrs. Pheasant's failure to give her husband what was described as the demonstrative affection which he needed entitled him to a divorce. His lordship gave the positive answer when asking himself whether it was reasonable to expect this petitioner to put up with the behaviour of this respondent, bearing in mind the characters and the difficulties of each of them, trying to be fair to both of them, expecting of them neither heroic virtue or selfless abnegation. My lady, we agree with the submissions on the part of the petitioner that the modern law requires a three-stage test, and we approach that test head on. We also agree with the petitioner that the outcome of the first stage of the inquiry is beyond dispute. The respondent not only accepts, but is rightly proud that she was the mastermind behind rallying all the women of Sparta and Athens, both to abstain from intimate relations with their husbands, to assist in focusing their minds on securing lasting peace, and also to occupy the Acropolis, so as to deny the warring Athenians access to the treasury. She makes absolutely no apology for her creative and topical approach to advance her cause and that of the wives, mothers, sisters, and daughters, to break the political deadlock, and she asserts that any short-term pre-epic pain has led to long-term universal gain. So, my lady, the jury may ask what she could have done otherwise to advance her cause throughout the Peloponnese. Well, here in London, we are perhaps fortunate to live in an increasingly enlightened civilization. 101 years ago, the franchise was extended, albeit tentatively, to women for the first time. And 100 years ago, on the 1st of December this year, Lady Arden took her place in the Mother of Parliaments as the first female elected member. And in more recent memory, the United Kingdom has enjoyed, if that is the right verb, 2 female prime ministers. In Athens, on the other hand, the respondent is denied all these rights. She cannot vote, she cannot stand for election. Indeed, she cannot hold any public or political office. Using only the legitimate power at her disposal to encourage leaders to reach a rapid consensus, she did not overstretch herself. She did not seek to usurp her place in Athenian society. She did not take over the government. She did not reverse the discrimination that she suffers as a woman in Athens, nor act in an undignified manner. She sought only to bring an end to the ruinous war between Athens and Sparta. So, my lady, we turn to the second stage of the inquiry that requires an analysis of the objective benefits of the respondent's actions and the subjective effect on the petitioner. How successful, we ask, was the respondent in bringing about her laudable aims? Well, there were many benefits. She brought an end to the long-running war of attrition between Athens and Sparta, which, but for her actions, would have lasted 27 years. She brought about peace at a time when Athens was in a particularly desperate position. Barely 2 years previously, Athens had suffered a catastrophic defeat in its failed Sicilian expedition. My lady, the jury will recall in that folly, Athens lost some 10,000 hoplites and some 30,000 oarsmen. The male population of Athens was reduced by 1/3. Thirdly, she maintained the much prized Athenian democracy, and she delayed as a result, perhaps indefinitely, the ominous threat of oligarchy and a Persian incursion. She saved many, many men from death in a city where the male population is already critically lower than the female population. She enhanced domestic life. Through the considerably more destructive medium of war, both men and women were denied family life for far longer than the period encouraged by the respondent. Indeed, by going to war, a husband deprives both himself and his wife of a conjugal relationship, and either does not return through death, or returns bearing the mental and physical scars of war. Perhaps he returns even impotent. Sixthly, she benefited Sparta, where the combination of a long war and population decline would have been fatal to its long-term influence. My lady, The jury may be aware that in our legislature, we have our own so-called Spartans. 34 members of Parliament who on 3 separate occasions voted against their own Prime Minister's divorce settlement. One can only imagine the benefits if their wives and husbands had followed our client in withholding conjugal privileges in an attempt to persuade them to vote differently. More fundamentally, however, there is no evidence that the respondent's short-term actions had any negative impact on the petitioner at all. The petitioner has had the same opportunity as every other man returning from the war to reconcile with his wife on the declaration of peace. Nor is there evidence that the impact on the petitioner of the respondent's actions has affected him any differently to any other man returning from the war. Take Kinesius, for example. Was he not humiliated by his wife Miriam in full public view outside the Acropolis? Did she not tease him? Did she not promise to restore sexual relations with him, making a bed for all to see for them to lie in, and then, at the last minute, dashing his hopes? My lady, if any Athenian had cause to take exception to his wife's behaviour, it is him. But it is not he who brings a petition before the court. No, he and every other man has happily returned to his wife. So where is the evidence that the respondent's standing in Athens has been reduced by his wife's actions, or that he has been perceived negatively by any other person for the actions she took? Well, my lady, the jury will rightly look to Aristophanes, and they will find you wrong. Lady, the respondent actions were clearly designed to ensure that she, and indeed every other ancient Greek wife, could live happily ever after in peace with their spouse. The jury may think that it would be truly odd if this were to have the opposite effect on the petitioner alone. My lady, the third and final stage in the jury's evaluation as to whether these circumstances it is unreasonable to expect the petitioner to live with the respondent. This evaluation, we submit, cannot be conducted in a vacuum. To coin a phrase from the law relating to children, the jury will wish to step back and observe the broader canvas. There are, of course, a multitude of reasons why during the course of a marriage there might be a suspension or reduction in sexual relations between husband and wife that is entirely reasonable. Illness, as already mentioned, war, imprisonment, work, travel, children. The circumstances of a marriage are truly personal to those within it. My lady, in the modern era, the concept of enforcing sexual relations within marriage has been steadily erased by the court. Nearly 75 years ago now, Mr. Beaver's defence to a petition that he had deserted his wife on the grounds that she had denied him sexual intercourse was rejected by the High Court on the basis that her decision was based on, quotes, an invincible repugnance on her part that could not afford the husband any excuse for leaving his wife whom he had vowed to keep for better or for worse, in sickness and in health, etc. 50 years ago now, the Law Commission, chaired by that great progressive jurist, Lord Scarman, proposed the abolition of the matrimonial remedy of the restitution of conjugal rights. The jury will no doubt recall a time when a spouse who refused to restore sexual relations in breach of a court order could be excommunicated or imprisoned. Well, Parliament rightly accepted the proposal and legislated against it in the following year. And in our criminal jurisdiction, it may surprise younger members of the jury to know that it was but 27 years ago that the House of Lords, the precursor of this court, decided that there was no longer a rule that a wife was deemed to have consented irrevocably to sexual intercourse with her husband, and that therefore a husband could be convicted of rape of his wife where she had withdrawn consent. In his speech in the case of R, with which all their lordships agreed, Lord Keith said, "The status of women and the status of married women in our law have changed quite dramatically. A husband and wife are now, for all practical purposes, equal partners in marriage. A wife is not obliged to obey her husband in all things, nor to suffer excessive sexual demands on the part of her husband. We enjoy a live system of law," said his lordship, "that will always have regard to changing circumstances. Nowadays, it cannot be seriously maintained that by marriage, a wife submits herself irrevocably to sexual intercourse in all circumstances." In stating that there was no obstacle to the House declaring that in the modern times the supposed marital exception to rape forms no part of the law, Lord Keith quoted the then Lord Chief Justice, Lord Lane, who had said in the Court of Appeal, "This is a common law fiction which has become offensive and anachronistic." My lady, let the message from this jury be heard loud and clear that withholding consent to sexual intercourse is no basis in any society for the dissolution of marriage, let alone in the circumstances where this respondent has nobly brought peace and prosperity to her fellow citizens. Let this petition be dismissed.
Thank you. Does your learned junior follow?
My lady.
Either. Thank you. Very good. Well, I think this is the point in time when it is said that the judge is going to sum up. Actually, we've not had any live evidence, so I shan't be taking the traditional course of summing up the evidence. Otherwise, I would feel like the White Queen in Alice in Wonderland. Sentence first, trial later. We don't want to do that, do we? But I do want to pay tribute in three regards. The first is, you have heard some of the most tremendous advocacy this evening from counsel in front of you. It has been outstanding on any view. They have kept your attention because I've been watching. They have been very economic in their arguments, very skilled in developing their arguments, and they've laced it with just that right amount of humour to hold your attention. And I would like you to say in due course a big thank you to them for giving up their time, for being here to do it with you. It has been a superb experience to listen to it, and we don't always have such skill here. The second thing is I want to pay tribute to the drafter of the Moot, whom I believe is my learned colleague, Sir Rupert Jackson. And it is a remarkable thing that you have put this together, and I hope you've been pleased by the result of the argument. Hasn't it been tremendous? Good. Another third tribute I want to pay, and I want the jury to have this in mind, is I would like to pay tribute to Aristophanes. This is over 2,500 years ago, but it's a very modern dispute. And what's more, he's able to bring this dispute, underlining its gravity, and yet making it a comedy. Just imagine what effect this would have. It operates at many levels. It's about the distribution of power between the two genders. Women were being ignored in the war, in the Peloponnesian War. This was a radical thought for Sophocles. He wanted to make sure the women had a voice. So he dreamt up this extraordinary script. When I came to the bar, and there has been some reference to the fact there haven't been many women at the bar or judges until relatively recently. When I came to the bar, there was a very popular book called Learning the Law, written by my professor at university, Professor Glanville Williams. And he said, well, when it comes to women becoming barristers, it was thought that that would not be a very good idea because when it came to the battle, they would not be up to the hue and cry of advocacy. All I can say is he had never read Lysistrata. She was well up to it. And then it operates at the next level. We see a private dispute between two people who are a married couple in the story, but in fact it's a dispute between, a struggle between individual benefit. The husband wants the individual benefit of his wife against the wife standing for the public good. So it's operating as a dispute. When does the individual have rights to prevent public benefit? And that's something that the courts here are constantly dealing with. Many issues which may seem to you humdrum, like immigration, some of the criminal cases, disputes in insolvency, they're all because society has an issue, and that this is just one little reflection of it. So for me, this was an exciting evening as well. I was pleased to see that just occasionally the Latin came in, forum shopping, forum being the Latin for the marketplace, and the curator in Greek. So it was a brilliant blend of the serious and the comedy. But now I think you've got to make up your minds as to which way you're going to do it. So the choice for you is whether you give the husband the divorce he seeks, or whether you dismiss the application on the grounds it should never have been brought here and was brought for scandalous reasons, and on the grounds that the wife was acting properly and for the public benefit. Are you going to take the vote?
Yes, well, I'll do the country.
Oh, please do.
We'll try and do the jury vote.
All right. Shall I just call it out again?
Yes, you invite people who want to give the vote to raise a hand, perhaps. Give the divorce to raise a hand.
Right. Could we have a hand from those who would like to give the divorce to the husband? And then Sir Rupert will take us.
1, 2, 3, 4, 5, 6, 7, 8, 9, 10, about a dozen.
And those who would like to dismiss this petition? Oh, it's overwhelming.
I would say about 50.
Thank you.
But in Shabai, the majority, if you're accepting majority verdict, the great majority of the jurors have refused.
I will accept a majority verdict. Thank you very much indeed. Petition dismissed. But could I ask you to thank the very able members of the bar who very kind, they said, they did this voluntarily, but it's all at the end of a long day, and I think you really have done a fantastic job. Thank you.